You should be all good to go.
Yes, sir. So good morning, everyone. Good morning, commissioners. Good morning, staff. Good morning, whatever members of the public may view this in the future. My name is Jansen Evelyn. I'm the vice chair. Our noble chair, Stephanie Swerf, is um, out of commission for the commission today. She has a prior commitment. Can we do a quick roll call prior to convening?
Eileen Levitt, Commissioner.
Kimberly Press, Commissioner present.
Gina McKnight Smith, Commissioner, present.
Noah Matheny, Commissioner, present.
And I think that's it. And what about staff? I mean, do we typically do roll calls for staff? I'm trying to
Yes.
recall them.
Yes,
Yes.
I'm always a few minutes late.
no problem. Nicolette Young, Assistant Director.
And Spencer Dove, Special Assistant to the Executive Director.
Okay. Well, being that we are light on staff today, I imagine this is going to be a relatively truncated meeting. However, I want to, before we go to the reports, whether it be the chairperson's report, whoever is presenting it, along with the staff reports, I want to make sure there's no one here from the public, and we want to give space for public commentary. Hearing none, we will proceed to the chairperson's report. We know that our chairperson is not here. Rather than me come and freestyle a report, I would rather proceed over to the staff reports. So, Spencer, I will lean on your guidance in terms of how we're going to present it in the event. Since the executive director Horton is not here, will someone else present his report, or do we, as the commissioners, having received them in due course, we just review them, and if there are any questions, we present them?
I believe that the commissioner should review, and if there are any questions, please let him or I know. And we'd be happy to follow up. He did not leave me with a written report to share. We can move to Nicolette's report, and then I will go and try to get our esteemed general counsel, since she did prepare the legislative briefing.
Okay, very good. Nicolette?
Okay, good morning, everyone. You have my report that has been submitted, and I'm happy to answer any questions that you may have at this time regarding our budget or any personnel matters that have been cited in the report.
So I guess my only question is the deputy director, being that Yolanda Sonia went to the bench or the magistrate court. What is you said anticipate filling in the near future, but what is that in terms of specificity, in terms of timeline?
So I don't want to speak on behalf of the executive director. He will make a determination on when that position will be filled. We have had some internal discussions that, of course, we want to try to, have cost containment as far as salaries are concerned. So there may be a slight delay in filling the position to ensure that we are, abiding by the state guidelines as far as personnel is concerned, and contributing towards cost containment for the agency. So the position may be filled in the next few months, or it could be filled sometime next year. But that will be the discretion of the executive director on when he would like to fill that position. So I didn't want to commit and say the position will be filled within, the next year. I mean, not year, but, within the next couple of months. But I wanted to kind of give us a little leeway with saying that it will be filled in the near future. So that statement may change soon.
So I guess my question is just more technically, has the position been advertised yet?
No, the position has not been advertised at this time.
Okay. And do you anticipate that it will be advertised in the very near future?
That will be the discretion of the executive director on if that position will be advertised.
Okay, because I imagine
I don't want to misspeak. That's the only thing.
Okay. Well, I imagine you may wait till the new fiscal year to advertise, but you could advertise now and still it wouldn't be filled until July 1st, but
That's
okay.
correct. That's correct. We do have the flexibility to, if we do plan on filling a position within the next 3 months or so, we do have the flexibility to be able to go ahead and do the recruitment with an anticipation that the position will be filled within the 3 months of the first of the fiscal year. But that has not been something that we've engaged in conversation with at this time.
Okay, and my last question is Assistant General Counsel. How many Assistant General Counsel positions are there? There's obviously Glendora, and then how many Assistant GCs, including the vacancy?
That would be 4.
Okay,
But I don't,
okay.
I'm sorry, Glendora, do you want to speak on behalf of
No,
your unit?
yeah, no, there's 3 now, and I was just while I'm late, I was just finished interviewing the 4th one.
Excellent. Okay, all right. You answered it in one fell stroke. So okay, so that tells me you've advertised, you're interviewing, and you'll be making a decision in the very near future. All right, excellent.
Very, very quickly.
Any other commissioners with any questions with regards to Nicolette's report? Hearing none, we can proceed on to, since the most honorable and noble Glendora Hughes arrived, she can present her reports.
For my report, you have it. I don't think there's really a lot to report in terms of we're still waiting on the Fourth Circuit to give us a decision on our case that's pending. We still have this really weird case of trying to get this ramp, and they keep writing us checks. In the Cromwell case, where the respondent is supposed to be putting in a ramp, and they keep getting rejected by the permits office in Anne Arundel County. Whatever drawings that they're submitting, they keep getting rejected. But it's making money for us because as long as it keeps being rejected, they have to, part of the consent decree with the court is that they have to send us money for each day that ramp is not being put in.
Interesting.
Yeah, so we got a catch-up check of around $7,000 in May.
Mhm.
Well, close to $8,000 in May, and so the clock is still ticking.
That's interesting. They haven't moved with any more deliberate speed.
Well, I think they've moved, but I don't know who they have creating the ramp. I don't know, but or whether the permit office really, sometimes permit offices really don't know what they're doing when it comes to, the ADA and the perspectives for the ramp and what have you. So you get this conflict. So we really don't know where the discourse is, but this is the 3rd rejection. They've submitted drawings, so they have been actively trying to get it done, but they can't get past get the approval from the permit office. So
Yeah, and so this is where I can't get involved because I oversee
yeah, right, exactly.
but it's one of those things where typically in my work, I would just, in situations like this where you're having difficulty navigating the development review process, I would just convene a meeting with staff and the applicant so that we can get to the bottom of it. But this is when I'll just stay out of.
Yeah. So we'll just happily take their money till they get it straight. And the reject of the 3rd time was May 15th of 2026. That's when they submitted their 3rd drawing and it was rejected.
And this is with IMP, inspections and permits, right?
I assumed, I don't know.
Okay. All right. Well, are there any additional questions from any other members, from any other commissioners? Hearing none, I want to thank you so much, Honorable Glendora Hughes.
Thank you so much as well, sir. And whatever's next, I'll be doing the legislative update.
Well, you might as well transition to that.
Might as well.
I don't believe there are any other staff reports.
Okay.
And so, Spencer, if I'm inaccurate, let me know, because my video is only pinned and I can't unpin it from. And normally I have no difficulty navigating Zoom, but if there are additional staffers that need to present reports, please speak now if ever hold your peace. Otherwise, we can transition to the 2026 legislative session wrap up.
Okay, let me get my cheat sheet.
And I just emailed the written version of what Glendora is about to present over to everyone.
Excellent. Thank you.
Yeah. So there were the report is much more detailed. I'm not going to go verbatim, word for word. You can read it at your leisure at night to put yourself asleep. But there were some key pieces that did pass into law. I'm kind of going to skip around. One very important piece that passed in the law was the House Bill 772 that House Bill 315 and it's Chapter 772 in the Senate bill. And what it deals with prohibiting a landlord from doing a couple of things, from utilizing a person's credit score who receives subsidized housing vouchers, whether it be a Section 8, whether it be funding from a nonprofit, because that has been a barrier for people to having access to housing, is that, people who are struggling to pay bills before they were able to get subsidized housing, they ended up with bad credit scores. So this bill will prohibit landlords from utilizing credit scores as a screening mechanism to screen people out from having, particularly when it doesn't make sense when you're guaranteed the rent, in some cases, the entire rent with some of the nonprofits, or in Section 8 housing, the majority of the rent is paid, and with the responsibility of the tenant paying a small portion. And also it prohibits the landlord from using income of the tenant to determine whether they can pay the entire rent from their income, when in fact you're already guaranteed the money. And so it sort of addressed that issue that came up after the source of income bill was passed, that when landlords start switching to finding a loophole to be able to deny persons who had vouchers or subsidies that assist them, and that this bill was directed to eliminate those challenges for the tenant in attempting to get housing. So they can't use their income. They can't use their credit score or lack of a credit score, or even if they had a adverse credit record at the time they did not have a voucher, they can't use that score in terms of using it to screen persons out of their from getting housing. It's a bifurcated bill that addresses something that the Department of Health and HCD, Health and Community Development, it created this positive rental payment history that HCD is overseeing, that they oversee. We will be overseeing the credit score portion, but there's this other portion that it's something unique that I hadn't seen before or heard before, but is attempting to build a positive bank of referrals for persons who are positively paying their rent on time with and that the Department of that the landlord must notify the tenant upon them accepting them that they have the option of allowing the landlord to report to a consumer credit bureau information that the tenant is in good standing and positively paying their rent. And this is an annual re-up, and that the tenant must pay a minimal fee to cover the cost of the landlord making that reporting. And then there's certain criteria of if it isn't done or if the tenant fails to do it, what HCD needs to do. But that, and then they have to, HCD has the secretary have to pass regulations to carry out that portion of the statute. So it's a combo statute with HCD and us, but our portion deals with our analysis of source of income discrimination is to look at the prohibition of using credit scores or using the tenant's income to justify screening them out. Any questions?
I don't see
Hearing none.
any, Glendora.
Okay. There is a reporting. House Bill 14 is about reporting about bullying, harassment, intimidation, collecting and reporting requirements for county boards of education. One of the things that, and I think this is to sort of force data collection, because a lot of times people don't know what's going on in the schools. They don't know how many incidents there have, because schools have been very protective and worry about their reputation. So they have not been accurately addressing the issues until there is one big case that happens and it blows up, and then you find out, oh, that this has been going on for some time, or oh, there's been numerous cases, but they've swept it under the rug. So this bill is going to mandate that that there be an annual report to the State Board of Education, so that when the State Board issue their annual report, that there is some data in there about the level of bullying, harassment, intimidations that are taking place in the schools, in the various schools around the state, so that there can be an ability to assess the problem and what kinds of resolutions there can be to minimize and to reduce this type of behavior. And that's the purpose of House Bill 14, which passed. Any questions? Okay. The next bill, House Bill 439, that bill is pretty just a name change. It's pretty straightforward. It's the Office of Deaf and Hard of Hearing and the Maryland Advisory Council on Deaf and Hard of Hearing being able to rename themselves as the Office of Deaf, Blind, and Hard of Hearing. And also the Advisory Council would be Deaf, Blind, and Hard of Hearing. So it's simply a technical naming bill that was submitted by those entities to change their name. Probably one of the most significant bills that passed from my perspective is House Bill 573, Fair Housing Discrimination Regulations, Intent and Discriminatory Effect. For those non-lawyers, this bill is to codify what we call disparate impact into state law. And the reason why it's important, because on the federal level, it's being attacked and removed or neutralized by both the EEOC and HUD. And the significance of it is that disparate impact doesn't require the showing of intent. It requires the showing that whatever policy, whether neutral, has a disparate impact on a group of a specific group of people that are protected under the statute, i.e., particularly the cases that early on cases that were employment cases that address disparate impact, the Griggs case and so forth. They basically showed that there were testing requirements that were created to basically screen minorities out of certain jobs. You saw that a lot in the fire departments and police departments. That had no correlation to the job at all. It was just there to provide screening folks out. And at a time where African Americans' access to education was limited, so you created these tests that were given that had no relationship to the job, but was created specifically to say, hey, it's neutral, everybody has to take the test. But when you looked at the data, the higher percentage of failure was in the minority group versus the predominantly group. And so disparate impact is usually a statistical data-driven type of discrimination that you look at what was the impact on that community. You see it a lot. You saw in housing, and I think it's more recent is to address the housing, where you had developments of communities that created criteria that looked neutral on its face, but it effectively screened out minorities from being in certain communities or building in certain communities. Not only in terms of people being able to purchase in a community, but in terms of a developer being able to build, such as affordable housing in a community, i.e., there was no discriminatory intent, but the impact was discriminatory. And so when you're having the federal government backtrack from this very important tool to address systemic discrimination, Maryland, through this bill, has codified the theory of disparate impact into the statute, and it amends our statute, Title 20, at Section 705 of our statute. The definitions are there in the statute, and we basically are saying that we can continue to enforce it. But on the other hand, the issue is that these cases, if we should have these cases, that our federal partner will not accept those cases for payment from our contract. Either EEOC or HUD will not accept cases that apply this theory. This applies to the housing part of our statute. It's codified in housing. There's been off and on a companion bill to codify it in employment, but it doesn't mean that we're not going to use the theory in employment, simply because we just can't submit the case to EEOC. Now, one of the tricky things is that whether or not, in terms of ours being substantially equivalent, because they're playing games with that whole issue, whether or not they would consider us being substantial, particularly HUD, equivalent, because we have to have a broader or a different theory in law than they do. But this is what this statute does. It also, another bifurcated part of the law, again, is directed to the Department of Housing and Community Development, where they're being directed to promulgate may promulgate regulations to enforce the affirmatively forwarding fair housing, which passed a couple of years ago, in which the local governments are required to administer programs that they receive money from, grants from, to affirmatively further fair housing, and that they should come up with a plan to do so in their subdivision, and that the oversight of enforcing that part of the statute is with the HCD, with the House and Community Development. The secretary is mandated to create some regulations in terms of enforcing that. That was another bill that was put in a few years ago because of, again, the federal government backtracking on this regulation of affirmatively furthering fair housing. And the state said, well, we're not going to backtrack. We're just going to codify it. And that we will continue to follow that policy as opposed to backtracking from that position. So that's the combo that's in their law. But the important part is the codification of disparate impact theory into the law. Any questions?
Yeah, any commissioners that are still awake after this law school presentation?
As Eileen yawns. Okay. All right.
No, she's laughing. She's laughing. She's laughing. No, this
when
was
it comes on appeal,
It was,
you better know how to do it.
It was, I know, but it was, disparate impact I get. I was just trying to figure out, like, I was looking at all the stuff and I just didn't see anything that passed that codified disparate impact. And I think I got lost in all of the explanation of everything.
Yeah, I mean that's
Bill
because that's an
573.
that's an upper level seminar, legal seminar response. So yes.
Yeah. I just was trying to find, I live in that world, so I get that
Yeah.
disparate impact.
Yeah.
And been in the commission long enough to know that this is becoming an issue.
Yeah. It's House Bill 573. It's on the second page of Spencer's bills that pass.
Okay.
Okay.
It's which one is it?
House Bill 573.
Oh, fair housing. Okay.
Fair housing,
See,
housing discrimination, regulations,
effect.
intent.
Okay. Okay.
That's it.
Okay.
Yeah. Then we have a very interesting bill, Senate Bill 439, Employment, Fire and Rescue, Public Safety Employees' Use of Medical Cannabis. We, was it 2 years ago? Or yeah, I think 2 sessions ago, when we were trying to get a bill legislation that would allow to address the usage of medical cannabis in the workplace, the fire union, they came and testified about the usage of medical cannabis, and there was a very interesting testimony from a young lady who had suffered some severe injury as a firefighter, and she spoke about how heavily medicated she was on opioids because of the pain that she was suffering. And she said most of the time she spent her days being out of it until someone said, have you tried medical cannabis? And so she said no. And so she did with her doctor, got certification and started testing to see if they would help her pain. And it did significantly change her life in terms of addressing her pain and letting her to get off of opioids and function. And because of the types of injuries they had, that many firefighters are suffering from pain, and they were wanting to have, with certain criteria, the opportunity to be able to use medical cannabis. This bill did succeed in passing. There are other states where that medical cannabis is permitted by the fire and rescue public safety employees, again, with certain criteria that they have a written certification, that they hold one to be able to use it, and that even if they test positive for the cannabis components, that they would not be used against them to terminate them or to discipline them. But they have to have the written certification. And there are certain limiting, segregating them or reclassifying them for using it. And that there are certain requirements that are that they must adhere to in using the cannabis, in terms of when they're on duty versus off duty, because the body of usage of medical cannabis, the reason why it was important is that even if you stop and you're not utilizing it, it still shows up. It can still show up months after you stop using it. And that's why it's very difficult that in terms of those entities, those jobs where you're being tested, that you're going to have a dirty test, because it stays in your system for a long period of time. So this was successfully passed for employment, and they may use medical marijuana, cannabis, with certain restrictions and criteria on their usage and when they can use it and when they have to address their particular medical issue. Any questions? Hearing none. The last one is it's more of a technical. I think the counties wanted to, this bill would allow that if someone came and filed with us and they want to go under, filed a court case in a court under the county ordinances, that's usually Montgomery County, Howard County, that have the right to go into court directly. They don't have to go through the administrative process. That they would accept, the court would accept a filing with us, giving as an exhaustion requirement for them to be able to go to court and filed a civil action for discrimination under the county ordinance.
Okay.
And you can read for your leisure the bills that were rejected, that failed and did not pass. One of them was the menopause bill that did not, it got hung up and time ran out. So are there any other questions? I think Spencer did a very thorough write-up on everything that would give you, and plus there's a link that if you want to go look at the bills themselves, you can go in your email. There's a link for you to be able to click on those bills that pass for your further reading and understanding of those particular bills. And it's something to keep in your, file, because should a case come up on appeal, that you'll have something to refer to.
All right. Glendora, I want to thank you. Like, that was very thorough. I know I made a joke earlier, but seriously, this is important to understand what the commissioners, but moreover the staff, has supported to ultimately get through. And I want to reinforce what Glendora mentioned. We need to pay attention to the bills that failed so that we can utilize our networks and our resources to work with with our delegation, whatever it be, Montgomery, Howard, Prince George, Baltimore, just to see who we can get to potentially take another stab at it. As many of you know, when you're looking at General Assembly, sometimes it takes a couple of bites of the apple to get the legislation passed. So yes, let us not grow weary in doing good. And um, I do think that looking at the bills that failed is a critical next step and is vitally important to do. So,
To your point, I neglected to point out our education bill failed. And we will be going back with the bill. We're going to be meeting with a lot of um, the partners and all opposition to get a clear to get their input. Part of it is that, our postpartum review of it is that one, this was a very complicated bill to draft, and we didn't have a bill to show people until late. So there was a lot of amendments that we had to add as we were talking to folks, and they started reacting to the draft that we finally got out of legislative reference. And so part of it is that when it got out of the House, but when it went over to the Senate, and they were running out of time. There just wasn't time to have those conversations. So it is important to have the conversations with your delegations now, once the primaries are over, to let them know about the bill, get their read on the bill, so that it helps to make things a lot easier during session, because things are very hectic. And it's hard to get an opportunity to meet and explain anything to the delegates or the senators while they're running around with 5 million other bills. And we do plan on meeting with key persons that were on the Senate side. We and reinforce key persons on the House side. But if you can reach out to your respective county delegations and let them know. And we will have, once we get through the primary, we'll have a bill with incorporating those amendments that we asked for, and any other tweaks that we may have after we have conversations with the various constituent groups that have been involved with this bill. We will share that with you so that you all can have that reach, because for me, that's the important part for you as commissioners when it comes to legislation, is to reach out and connect with your county delegations about something that we are sponsoring as departmental legislation.
no, absolutely. Thank you for that. Is there any remaining, or is there any additional old business or even new business? And I see Eileen looking intently saying no. Well, if that's the case, I just want to make sure as we adjourn this meeting, that I say thank you to all of my colleagues on the commission. But more importantly, thank you to all the staff for your hard work all the time. The challenges that we are facing here on the state level, on this local level, they are magnified by what's happening, by the madness down in Washington. We saw what happened on the latest Meet the Press interview. So while the federal administration's approach to civil rights, like it really makes the work of MCCR even more critical than it's ever been in its history. And so, and you all know this, the enforcement of state laws is literally the last or the absolute barrier that's protecting our neighbors from discrimination in housing, in employment, in public accommodations. So our responsibility has just been more magnified. So not to end it on some Spider-Man stuff, but with great power comes great responsibility. Thank you for your tireless dedication to this critical work. And this meeting stands adjourned. All right,
Take
everyone.
care, everybody.